Ashton.
Thank you, and it's a pleasure to speak under your chairmanship, and thank you ever so much to my friend for bringing this debate, my honourable friend. I think there's an interesting paradox at the heart of this scheme. The fundamental eligibility requirements are that you must apply as soon as is reasonably practicable and this should normally not be later than 2 years after the incident occurred. The time limit for adults. The time limit can be extended due to exceptional circumstances, and if the person was under 18 at the time of the incident, an application must be received by their 20th birthday if the incident was reported to the police before their 18th birthday, or within 2 years of the first report to the police if the incident was reported to the police on or after their 18th birthday. I mean, I was sexually harassed as a teenager, nothing that would have met a criminal standard, and it never occurred to me to go and do these sorts of things. It is not something that enters the head of 18 or 19 or 20-year-olds, let alone the victims of child rape and sexual abuse. We should be absolutely accepting and implementing the recommendations of ICSA. It is a basic moral requirement. But secondly, when we look at those exceptional circumstances, if you haven't managed to apply as soon as reasonably practicable or within the 2 years, due to an exceptional circumstances, the application could not have been made earlier, and the evidence provided in support of the application means that it can be determined without further extensive inquiries by a claims officer. That is a much tighter exceptional circumstances exception than most legal exceptional circumstances exception rules. It basically requires that there's no work to do on the part of the agency who would be required to do the investigations. I don't understand why whether or not people get compensation is determined by what is required in terms of inquiries by a claims officer. I don't think that represents justice. And when we look at the number of claims that have been refused, there are significant numbers of claims being refused, nearly 2,000 a year because they're not submitted within the time limit, and another 765 because of failure to report as soon as reasonably practicable in 2023 to 24. What we don't have statistics for that I'm aware of is the number of people who didn't apply in the first place because they knew that they wouldn't meet those eligibility criteria, but I suspect it's substantial. And it seems to me that it is very much an accident of your life chances and various other instances around you, whether or not you hear about this scheme in the first place and whether or not you can meet those requirements. And then that's no way to determine whether or not people should receive compensation. At the moment, we are listing Crown Court cases for more than 2 years hence. The police can take more than 2 years to investigate a crime. It looks to me like about 21% of claims against the criminal injuries compensation scheme take more than 2 years to conclude. In fact, 2.8% of them take over 5 years to conclude. So where the state engages with any of these processes whatsoever, we habitually accept, although we may not like it, but we do fundamentally accept and have done for some time, that it can take the state more than 2 years to deal with a crime. But we do not accept that it can take more than 2 years for a victim to deal with a crime. That seems to me to be a fundamentally irrational and indefensible position. I would also add on this point that we will let you have a claim for breach of contract in this country 6 years after that breach of contract occurred, but we won't let you take more than 2 years to process your trauma. That is not, in my opinion, the right position for the state to take.